Drunk driving offenses in Indiana are divided into two different types of charges: operating a vehicle while intoxicated and operating a vehicle with a blood alcohol concentration of 0.08 or higher. The second charge is usually referred to as the chemical test by practicing attorneys. The actual operating a vehicle while intoxicated charge is not impossible to defend against in court. Intoxicated is a legal term defined by statute, and proving it beyond a reasonable doubt relies on the state presenting evidence based largely off of the officer's subjective beliefs and observations on how you performed a series of standardized field sobriety tests. Many police vehicles are now coming equipped with audio and video recording equipment that will allow for us to see for ourselves just how unsteady your balance is or just how slurred your speech is, as these are two principal indicators that officers will use to argue that you were intoxicated at the time of your arrest. A chemical test failure charge is a little bit more complicated to defend against. The chemical test relies more on scientific principles than of subjective observations. Your BAC is either higher than 0.08 or it's not, and if it's higher than 0.08, you are considered to be guilty of that offense. This is what's known as a strict liability charge. Even if your BAC comes back higher than 0.08, certain steps can still be performed to create defensible issues for you. If you took a certified breath test, those machines aren't infallible. They do break down, they do have to be recalibrated, and they may result in a reading that isn't completely accurate depending on certain other circumstances. If you took a certified blood test, there are a number of additional steps with regards to the chain of custody that need to be observed before those results would be admissible at trial. Contacting an attorney will help you to determine what issues are available for you on those charges. Far too frequently, people get arrested for DUI charges and decide that there's absolutely nothing that they can do and they give up. You should never give up if you're accused of a criminal offense, even a DUI. Contact an experienced DUI attorney to discuss what options might be available to you and what defenses you can pursue. If you've been accused of a DUI offense in the state of Indiana, call my office today at 317-989-1129 and we can discuss the facts of your case and the options that are available to you.